Nebraskans Unafraid has been made aware of the case of a person forced to register who is hospitalized and gravely ill in an intensive care unit. This person is immobilized in bed, attached to all manner of medical monitors. Friends of this person contacted the local sheriff's office, the Nebraska State Patrol, and local police with this question. Due to this person's medical incapacity, could some arrangement other than personally reporting to the sheriff's office be made for him? The answer was no exceptions. He must report in person. Nebraskans Unafraid submits that this is ludicrous, and it demonstrates that the true intent of the registry is to inflict cruelty and inhumanity. Nebraska's unyielding reporting mandate. Nebraska law mandates strict in-person reporting for individuals on the sex offense registry. Initial registration occurs at a Nebraska State Patrol office. All subsequent updates, including changes to address, employment, or school, require an in-person visit to the county sheriff's office within 3 working days. Depending on their registration duration, 15 years, 25 years, or lifetime, individuals must also report in person annually, biannually, or quarterly for verification. With no explicit provisions for medical incapacity, this rigid framework means failure to comply, even due to severe illness, can result in a Class 4 felony charge. A glimmer of existing exceptions, yet Nebraska law itself offers flexibility. State Statute 29-4005 explicitly exempts people forced to register from verification while in custody or under an inpatient civil commitment. This acknowledges situations where physical presence is impossible because location and status are known. For those incarcerated over 3 working days, written notification of incarceration is accepted. This precedent for non-in-person reporting stands in stark contrast to the no exceptions stance for a gravely ill, hospitalized person. An ICU patient is functionally equivalent to someone under inpatient civil commitment, making the lack of accommodation arbitrary and inhumane. Legislative intent versus cruel reality, Nebraska State Statute 29-4002. States the registry's purpose is to protect communities and assist law enforcement, explicitly forbidding retaliation. However, current application contradicts this. A person gravely ill in an ICU poses no public safety risk. Their location is known and they cannot commit new offenses. Forcing them to physically report serves no legitimate protective function, instead becoming a punitive act risking a felony charge. This disconnect undermines the registry's legitimacy, revealing a system that inflicts deliberate cruelty. This case exemplifies how inflexible laws lead to absurd and cruel outcomes, particularly for vulnerable individuals like the elderly or disabled. It leaves the family and friends in the impossible situation of having to untangle the mess in order to prevent their incapacitated loved one from facing a felony charge. Such rigidity demands legislative action. Broader critiques and paths to compassion nationally. Sex offense registries face constitutional challenges, particularly under the 8th Amendment, cruel and unusual punishment, and due process clause and under the 5th and 14th Amendments to the Constitution, especially for vulnerable populations. Human rights organizations, including the ACLU and Human Rights Watch, consistently criticize these registries as overbroad, ineffective in preventing recidivism, and causing significant collateral consequences, like social stigma and reintegration barriers. Research shows that such laws create socioeconomic barriers and don't deter crime. The scarlet letter of registration stigmatizes individuals long after they have completed sentences. Despite Nebraska's rigidity, other states offer precedents for medical accommodations. Some have compassionate release for terminally ill inmates. The ACLU has challenged registration mandates for individuals with HIV as discriminatory under the Americans with Disabilities Act, ADA. These examples underscore a broader principle. Extreme medical conditions should warrant adjustments to legal obligations when rigid enforcement serves no public safety purpose.